Well, what I was just going to say, when we talk about probable cause, we use it as a shorthand. It's probable cause of what?
So, Mr. Chief Justice, here it would be probable cause that an occupant is seriously injured or imminently threatened with such injury. Ordinarily, it would be probable cause to think a crime is being committed, but
Right.
here, as the government explained in its brief in Brigham City, the object might change, but the way that the standard applies and the level of certainty does not.
Why isn't it something like probable concern or reasonable concern? It seems to me that you're taking a totally different context and applying these things just because we're familiar with them and because authorities are involved. I mean, did they enter this home because they were concerned that, I forget the name of the individual, would harm himself? Or was it because they wanted to arrest him for a particular criminal activity?
So, Your Honor, the dispatch call was for a wellness check. But I think to get to your original question, the court has applied that probable cause standard even though the object of it might change in different contexts. For example, a civil vehicle infraction, that's not a crime, and the standard's still mapped onto it. And we think that it maps on to the emergency context quite well, because officers and first responders don't have complete information. They're just trying to assess whether there's an urgent emergency that is happening behind the front door, and probable cause would help them do that.
You'd say urgent emergency. I mean, let's just say as a patrol or whatever, he looks in the window and there's somebody who seems to be in some distress. Now, is he supposed to say, I can't tell if, he has a pain is, or if he's having a heart attack or whatever before, entering?
Mr. Chief Justice,
or even just lying on the ground. Why is that person lying on the ground?
Well, the court said in Fisher that you don't have to have ironclad proof that somebody is dying before you go in, but the standard is, under the emergency aid exception as defined in Brigham City, seriously injured or imminently at risk of such injury. And so I do think the court has fixed the threshold, but it said you don't have to have ironclad proof, and that's consistent with probable cause because, of course, probable cause also does not require ironclad proof. What it requires is a fair probability or a substantial chance, and we think that that strikes the right balance given the important and really fundamental interest in the sanctity of the home.
I think that's critical.